Welcome to our Facebook Live event on the Kyle Rittenhouse case. Now, we have all probably seen and heard step-by-step detail, excruciating analysis of the self-defense aspect of the Rittenhouse case, but that is not what we're going to talk about today. We're going to talk about the other side of the Kyle Rittenhouse case. We're here with two former prosecutors who are going to discuss some of the nuances that we've all heard of, how could the prosecutor possibly argue this, or how could this particular piece of evidence have possibly come into play? We're going to get the other side of the Kyle Rittenhouse story. I'm Kirk Evans, president of U.S. LawShield, and we're here with Richard Hayes and Emily Taylor, both former prosecutors. So let's get it started right there. One of the first things we all heard in this case was the reference to the deceased as victims. Is that appropriate? Is that common? What do you guys think about that?
I mean, Richard, how many times did you do that as a prosecutor? Every time.
It's a pretty common technique that you see used among prosecutors, and it makes me think of I think it's a Benjamin Franklin quote. Rather 100 guilty people go free than one innocent person suffer, and it comes down to when you are charged with a crime, you are cloaked in this presumption of innocence that's supposed to protect you. And the government, if they want to take your liberty away, they have to prove beyond a reasonable doubt that you committed a crime. And so whenever you see a prosecutor try to slip in, hey, these victims, it kind of presupposes the guilt.
Right. Until you're convicted, they aren't victims, right? They're
Good point.
Complainants, they're decedents, but they're not victims. And the idea is that if the prosecutor gets to say victim, 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 it prejudices the jury. Well, this guy did it. He created victims. That doesn't mean that every prosecutor in the world isn't going to try to do it until the defense attorney objects and the judge tells them not to. But yeah, that's pretty common.
Yeah, and it goes back to, and we're going to talk about these, and I think this is what's so exciting about this conversation is, the prosecutor's bag of dirty tricks. It's like the CIA book of dirty tricks by John Fitzgerald. It's there's some things that are kind of fair game. We see it in our practice, but I saw so many things in this case that is really unusual, and I haven't seen people talking about. So I'm really excited to have this conversation.
Yeah, and there's a spectrum of dirty tricks, right? So I mean, this is on the calling people victims is the least egregious thing you can do. I mean, and this trial and these prosecutors run the gamut from these not a big deal to there should have been a mistrial granted at the end of the day. I mean, this was dirty pool by the prosecution. So I think we'll talk about all of them.
Yeah.
Well, let's take the other end of the spectrum right there then. So, and a housekeeping matter, we are taking live questions. So get your questions in there. We'll have them right here and try to answer as many as we can during this time. So let's go to the next one, the other end of the spectrum, the risk of testifying in your own defense and the ability for the prosecutors to comment on whether or not you did so or whether or not you talked to the police.
Yeah, I mean, I think, we talk about the risk first because it's interesting. Richard and I talked about this when the defense was first presenting their case. We disagreed about whether or not Kyle should testify. Richard said, no, there's enough, witnesses, camera footage. You can establish the Self-Defense Act without putting him on the stand. I said, yes, I thought he should. Because he's so young. And I thought, yes, there's always a risk to testifying, but you put someone with that youth on the stand and have the jury remember, have him talk about the fear he felt and have them kind of look at this kid and really put themselves in his shoes. I thought that was too important. He did such a good job, but it was a huge risk. And the risk, of course, is cross-examination. When you put your client on the stand, you don't think you're risking prosecutorial misconduct on cross, and that's what we got here. Do you want to address that, Richard?
Yeah, and it's so interesting because defending yourself after a self-defense incident is hard enough when everybody's playing by the rules. And when you have someone who's tilting the scales of justice in their favor, or maybe not following all the rules, or being downright dishonest, it makes it very, very difficult. And our Fifth Amendment, our right against self-incrimination, it's so important because
sacred.
Yeah, it's sacred. Exactly right. And the decision whether to testify or not testify, I mean, the defendant is the only person who decides at the end of the day whether I want to testify or not testify. But it's so fundamental. I was just so surprised how this came out. In the trial, the prosecutor was trying to use it against him. His post-arrest silence, his why didn't you tell this story sooner? Why didn't you talk to the police? Why is this the first time we've heard all this? That is, Prosecutor 101. You know, we learn that in what we call baby DA school. When you go and they train you up on how to be a prosecutor, that's probably one of the 5 things they tell you never to do. And so I don't know. What do you think about it?
I thought a mistrial should have been granted right then and there. You cannot comment on that right to remain silent, and that's what he was trying to do. He might as well have looked at that jury and said he didn't talk on the scene because he's guilty. I mean, that's the effect of what happened, and you could tell by the judge's reaction. The judge was furious in the moment. I wish we could have kept that fury going a little bit longer.
Right.
It was deserved.
Yeah, and one of the witnesses that testified for the defense, he was a reporter. He after shooting, he was a reporter. He shot some video afterward. Went and spoke to an attorney before, but basically before publishing all the material and coming and testifying. And the prosecutor again, another sacred right to an attorney, commenting on that. And while that guy wasn't on trial, it just shows that they're not playing fair.
Yeah, and luckily, I mean, I think the judge has done a pretty excellent job in reprimanding the prosecution, but there are judges who will let that in. I had a judge in a case. We had a murder trial, and it was a U.S. LawShield member, and I made the scene in that case, and I'm on video in the police body cams in the scene, and we had long pretrial arguments about cutting me out, and and ultimately, because it is a commentary, the fact that he had an attorney on the scene, and the judge wouldn't do it. So it's really nice that this judge is I'm not going to say he's pro-defense so much as he's pro-constitution and pro-fairness.
Right.
Well, I know. So one thing I know both of you guys tell your clients is, 1, don't talk to the police unless we say so, and 2, get a lawyer immediately. Does this case change your mind?
Gosh, absolutely not. In fact, I mean, I think it's Kyle was probably damaged here in that he had a change in his defense team, because you want a unified strategy from a lawyer who understands self-defense and understands gun law from that first second. And I think we didn't quite have that here. Richard, do you want to talk about that?
Yeah, well, and I think it's understated how important social media is used against a defendant. And that happened in this case. That's kind of my standard whenever I meet my client for the first time. I give them the same instruction every single time. Don't post on social media. Don't talk to anybody about the case. You never know how it's going to be used. And just the optics. There's so many different things that could be perceived as hurting your case. And so you got to be so careful. You got to walk on eggshells. And any attorney worth their salt, they're going to advise their client that. An issue came up in this trial. A T-shirt. I think it was 6 months or so after the incident. It said free as expletive with an F. And they were trying to enter that as evidence that he was, part of some kind of, extremist group, essentially.
I felt a lot of sympathy for the defense attorney who was sort of arguing I wasn't his attorney back then. And the judge is like, well, that doesn't really matter, and ultimately it doesn't. But you feel for that defense attorney who's like, I wouldn't have let him do that, and now it's coming up at trial, and it might hurt my client. And he has to be a zealous advocate, and that opportunity was taken away from him because he wasn't there.
Yeah, you think about your trial as kind of like a movie that people are watching, and most of the time, trial, it's really just supposed to be a snapshot. Did this incident happen? Did it not happen? But so many of these things sneak in that happened before and after. What are you posting? Are you posting, controversial memes? Are you wearing controversial clothing with photographs of yourself in it? That kind of stuff sneaks into trial too, very regularly.
Well, while we're on that topic, I mean, I think, we need to talk about another issue that came up with, I mean, I think this is one of, again, on the dirty trick side of the spectrum that Kirk was talking about earlier, which is the prosecution commenting on related issues that happened before the self-defense incident.
Yeah.
You're talking about what we call propensity evidence. And so the prosecutor, without, and anytime you're going to enter propensity evidence, which is, essentially some other act not related to the act that you're actually on trial for, that might prove your, your propensity, your tendency to behave in that way. I mean, that is not going to be admissible. You need to approach the judge, and you need to talk to them before, because, I mean, it's mistrial worthy if you don't.
Yeah.
And so the prosecutor, without clearing it with the judge, just starts into this line of questioning about how Kyle may or may not have said something in the weeks before this incident about shooting someone, which has nothing to do with the incident, absolutely should be inadmissible. And yet, and he did it that way, I think, I mean, frankly, I think he was trying to get a mistrial at that point.
Yeah. Yeah, and I wondered. I saw a few of these circumstances where, you know, the prosecutor's thinking maybe I didn't get a good bite at the apple this time. Let's try it again, and was trying to throw it. I saw a few things like that, and it was very concerning.
Oh, I think that's absolutely was part of the strategy here.
Yeah.
Well, so the big difference there on a mistrial, and you guys correct me if I'm wrong, if you have a mistrial for sort of a oopsie mistake, then the case is retried. If you can show that the prosecutor intentionally threw the case because they knew they were losing, you can have it with prejudice to where the case cannot be retried.
Yeah,
Is that right?
that's exactly
Absolutely right.
And that's something that I want, you know, a good reminder now. The jury's still out deliberating. Check the chat. Make sure we don't have a verdict yet. But, you know, if the jury can't come to a unanimous agreement, that's what a jury deliberation is. They all agree that somebody is guilty, or they all agree that they are not guilty. Anything other than a unanimous verdict results in a mistrial. And a lot of people, I think, have this misunderstanding that, okay, well, Kyle's free, or, you know, this person would be free, or whoever's on trial is free. And that's not it. The case starts over from the beginning. And that's our traditional mistrial. But yes, if we can show some bad faith, some malicious conduct, something that, you know, they're throwing it on purpose, they should get a
But it didn't happen in this
prejudice,
case.
yeah.
And I think, and this is just me speculating wildly here, but I think that this judge, because the case is so high profile, he doesn't want his hands in it as a mistrial with prejudice, because then he made the call. He
Right.
acquitted Rittenhouse, essentially, at the end of the day, is the public perception.
Good
You know,
point.
he wants this to go to the fact finder, because, and I think this judge thinks that Kyle Rittenhouse will be acquitted, but he wants it to be on someone else's hands, not his. I mean, judges are elected officials. They have to think about these things, and their general tendency, I think, is let the finder of fact decide. I'm not going to insert myself into that, pour someone out, you know, unless they really, really have to.
Yeah, good point.
All right, so I'm going to skip to a question, one that just came in live, and two that was actually posted to our page earlier before this event even started. So the prosecutor said, you can't claim self-defense for a threat you created. And then we just got a question from David who says, do you think that the jury might see Kyle as the initial aggressor by bringing an AR to a potentially dangerous situation?
Man, David, that's an awesome question. And it hinges on the principle of provocation. And provocation, we hear that, you know, there is a general self-defense principle that you don't want to be perceived as the person starting the chain of events that eventually leads to your use of force or deadly force. That's a good general self-defense principle that applies in, you know, in all cases.
That's not the law. That's the general rule.
Yeah, that's the general rule.
You know, go in with clean hands, right? Because that's what the jury wants to see.
But then we have the legal concept of provocation, which is really a technical, I am tricking this person as a pretext to using force or deadly force so that I can respond.
Yeah,
You know,
like, I know that if I say something bad about Richard's beard, he's going to come after me.
I'm jumping
And I
across
get
the
to- Yeah,
table.
and I get to shoot him because of that. But it has to be. I mean, that sounds silly because it is. It has to be that specific.
Right. So this does not meet the threshold of legal provocation. So, but it's a very interesting point. Good job, David.
All right, so Joe asks, do you believe the media should be kept out of the courtroom?
Oh, I go back and forth. Emily, you gonna kick this one off?
Yeah, that's really hard. I mean, I think that, you know, an open trial is so incredibly important. That's why we don't seal off courtrooms. You have to allow people in. That's part of the fundamental backbone of our criminal justice system here in America. However, gosh, this sort of crazy over-the-top media presence, it doesn't help get a fair trial. And so how do you reconcile those two? I think we have the same issue here with all of the protesters outside of the courthouse right now in Kenosha. We have, you know, you don't want to curtail people's right to assemble, their right to free speech, but you need to make sure that doesn't interfere with Kyle Rittenhouse getting a fair trial, which if the jurors can hear this uproar while they're deliberating, it's going to interfere. And so we have really, I hate this question because we have really delicate balancing act here to maintain. So I don't have an answer to that. Richard?
Yeah, I mean, I lean on the favor of what is, you know, you want to make sure that the person is getting a fair trial. Because at the end of the day, we're talking about a person's liberty. And I'm going to go with that pretty much every single time. But it is tough because we have an open jury trial system in the United States. You know, I've witnessed cases that have been overturned because the court closed the doors and didn't let people come in and watch. And so it's an important consideration.
But I don't hate your question. It's a lovely question. It's just a hard one to answer for us.
Yeah.
Well, on that topic, in the description for this event, there is a link to a publication called 3 Shocking Truths About a Good Guy with a Gun. So a different angle on that. Click on that link and get that publication. You can download it now for free. All right, so let's skip to one more of the zingers, sort of prosecutorial issues. What about the ammo debate? Is that common? Is he stepping over the line there, or is that appropriate?
Well, I see this play out too often. So going back to our spectrum of dirty tricks, it's on the higher end of the spectrum, but it's not novel. We've seen this before. And what we're referring to is in the trial, the prosecutor kept referring to Kyle, the ammunition of Kyle's choice was target ammo, full metal jacket ammunition.
Oh, how many times did he say full metal jacket?
Right. I'm surprised he didn't enter the director's, version of that, as an exhibit at trial, with the Born to Kill helmet, or put that into evidence, right? Why not? But at the end of the day, prosecutors are going to say whatever they need to say to, get the case in front of the jury and make it sound as scary as possible. He would have done the exact same thing if he had used hollow point ammunition.
Oh, yeah.
And so, that's one of those things where I say, use what you're comfortable with, use what you train for, let your attorney worry about that kind of minutia. But yeah, it's a dirty trick.
It is a dirty trick. The only time I've ever seen it not work that well, we had a murder client who he did have, he did have self-defense rounds, but these rounds were called aggressor safety rounds, and they're actually used by air marshals for airplanes. But so and they are, they've got little pellets in. They're definitely self-defense rounds. He had it in his, I think he was using .40 caliber. But it was great because every time the prosecutor was like, well, these are meant to be deadly. It was like, okay, the safety rounds you were using,
Right.
client. So it was wonderful. It didn't work very well.
Well, and Prosecutor Binger, that's what he kept referring to, over-penetrate. That's what this round is all about, passing through its target, reckless, the things behind it. You don't know what's going on. And
if it was a hollow point round, it would be, this was meant to kill. This was meant to cause the maximum damage. He would have used it against him regardless.
yeah, exactly right.
So the lesson there, use what is legal and what you are most comfortable with, and let the lawyers worry about what the prosecution's going to argue, because it doesn't matter what you use, they're going to argue something different.
Yeah.
All right, let's skip on. Okay, so what about the fake gun or the false gun charge?
Yeah, this one, and believe me, the Wisconsin law on there, who can possess a rifle in public, is hotly debated. But what I want us to focus on is the short-barreled rifle aspect of this, of what they were claiming. And eventually the prosecutor admitted, no, this isn't a short-barreled rifle. But what was so crazy about this, they had a police officer testify. The only evidence that they had was the rifle itself, and a police officer testifying that they didn't believe that it was a short-barreled rifle. And this is the crazy part to me. The judge, whenever he confronts the prosecution about this, is this a short-barreled rifle? The initial response was, well, Judge, the jury can measure it. And the judge went along with that, which is insane because we know there are some measuring a rifle barrel is very technical, and the chances that a jury knows how to do it correctly is very scary. But he kind of reversed his position on that.
He did, and I think we can back this up a little bit. So there is, and we are not licensed in Wisconsin, and this
Right.
law is incredibly complex. But there is some exception under Wisconsin law for carrying a long gun in public at the age of 17. But that exception does not apply to SBRs. So that's why this debate came up.
Mhm.
And ultimately, the judge dismissed that charge, did not send that rifle back for the jury to measure. And the thing is, the judge probably doesn't know how these are measured. The lawyers probably don't know how to measure an SBR. This is something, gun lawyers know, but it's something so technical. When we were listening to that happen, it made my skin itch because I thought the chances that a jury is going to do that improperly, determine this is a short barrel rifle, even though it's clearly not, were just so high. It was outrageous.
Yeah, and if you're carrying illegally, you're carrying either an illegal weapon or in a place you're not allowed to be, it affects self-defense, and so it really mattered in Kyle's claim.
Oh, yeah.
All right, let's skip to another one that has come up both in the questions before this event and afterwards. So the prosecution pointing a gun at the jury, again, across the line, misconduct.
So, and this is what, a pure idiocy, number one. Obviously someone who does not understand basic firearm safety. So let's get that out of the way first. But also, I mean, on our dirty trick scale, this falls, pretty close to the far end of the spectrum with all the mistrial worthy things we were talking about, because he's doing that. He's angling it in such a way so as to prejudice the jury. Plus, he's got his finger on the trigger.
Right.
And there is, other than the moments where shots were fired, I mean, you can check all those stills, all those photos of Kyle Rittenhouse. He has great trigger discipline. I mean, his finger is indexed the whole time. And so, I mean, ultimately, I think that's a misrepresentation of what was happening. Do you agree?
Yeah, and I call it bad trigger binger discipline, because that's the prosecutor.
Very good. His prosecutor's name is Binger, for anyone who isn't following this as closely as we are.
But the idea of demonstrating a demonstrative in trial is to show, it's to help a jury understand something that maybe they don't understand. And in every photograph that I've seen of Kyle, published online or otherwise, you see his finger indexed on the frame of the firearm. And so, is that a fair representation of how Kyle was carrying the firearm when he's walking around? Is he walking around with his finger on the trigger, pointing it at the jury? I mean, that's just to overwhelm their sensibilities, to make them feel emotional about firearms, to feel threatened. I mean, that's a real dirty trick.
Oh yeah, and that's, and it's using the jurors' brains against them, basically, because
Really?
even when you know that weapon is, a demonstrative, that the prosecutor is, unless he's a total idiot and it happens to be loaded, you're probably not going to get shot. Your brain doesn't understand that. I mean,
Right.
It's like you get that weapons focus, it shoots your adrenaline up, and I think that's all very intentional on the part of the prosecutor, scare them.
Yeah.
Well, so could a prosecutor ever demonstrate how someone was pointing a gun or using a gun?
I've had this come up in trial once, and in that trial, it was a long gun that was alleged, and the prosecutor wanted to, and the judge would not allow it. The judge said it was too inflammatory. In fact, the prosecutor was dead set in inserting the magazine into the AR, and the judge was like, under no circumstances will you do that. And the prosecutor made this big argument, well, that's what it looked like on this day, Your Honor, and the jury's got to see it. And the judge was like, the jury can imagine. I think they're always going to try for this reason. They want to scare the jury with the weapon. And then, really, that's the scary part of trial, is that there is so much up to the discretion of that one judge. I cannot imagine a case being overturned based on the judge allowing the prosecutor to demonstrate, hold up the weapon, do all of the crazy things even that ADA Binger did. I mean, I don't know. What do you think about the appellate issues on that?
No, judges have a lot of discretion, but at the end of the day, they have to do this kind of balancing act of letting in relevant evidence on one hand and not, prejudicing or overwhelming the sensibilities of the jury. And it's a balancing act, and it's tough. It's a tough call.
Yeah, what most folks don't appreciate is, so judges have what Richard just called discretion on a whole bunch of issues, and that means which I'm going to weigh this one. And those issues are almost never the subject of an appeal. There are certain black letter law items, such as referencing a defendant's refusal to talk to police or invoking his right to remain silent, where the appellate courts are going to review that. But on these judgment calls, this discretion, you're almost never going to get that reversed on appeal.
No.
All right, so let's, speaking of another one with sort of maybe discretion, how about these videos?
Yeah. So, and this is really, really bizarre because, and it's good and it's bad. We have a lot of video evidence in this case, and most self-defense cases are not as heavily documented as this. But I think too much emphasis is being placed on the videos. Videos are an important tool, but at the end of the day, videos can lie, for lack of a better term. Distances, times, perspectives, what people are perceiving. What do you think about perception, for example?
Yeah, and I'll say, although we are lawyers, not video experts, we actually, most of the LawShield independent program attorneys across the country were just recently trained by the Force Science Center, who consulted on the Kyle Rittenhouse case, were experts on the Kyle Rittenhouse case about video evidence. And they really scared us, because ultimately they are talking about, first of all, this frame by frame analysis we're doing in the Rittenhouse case is incredibly prejudicial because that's not how your brain works. Your brain
Right.
doesn't take in all that information. It certainly doesn't take it in that slowly. Also, you've got issues about things the camera sees that you don't see when you're in that moment.
Right.
And so, I think there's a lot of commentary on the internet right now, even from some lawyers who are saying, well, it's great that there's so much video out there, when ultimately the experts are going to tell you it probably isn't, because it's going to give the jury a false impression of what happened. And it's going to allow them, when we know yesterday the jury sat there in the courtroom. Well, they moved them back into the courtroom during deliberation so that they could go through the videos and watch them over and over and over again. And that is not how that situation played out for Kyle, and I think that is possibly damaging to him.
Yeah, it's an interesting point because, the cameras are going to pick up different lighting. They're going to see a different angle. Something that I think Emily brings up regularly that's very important is, you can't see Kyle's eyes. What is Kyle looking at as opposed to, maybe his head's pointed this way and his eyes are looking this direction.
So he's not seeing what you think he's seeing
Right.
by looking at the video.
And so it's almost a misrepresentation of Kyle's perception. It could be,
Yeah.
but it's an interesting topic.
Well, and I think, when we're talking about videos too, there is, for anyone who's watched since the jury's been deliberating, the defense filed a motion to dismiss on, I believe, Monday evening. And part of that issue was the videos had been altered, and those altered copies were not provided to the defense. And that's a really big deal. I mean, that's off the charts on the dirty trick scale if the prosecution did that intentionally.
Yeah.
And of course, they're arguing they didn't, but they have a duty to give that information to the defense, and their justification is just, but like, I didn't know that the video got compressed. How could I know that? Is just,
Yeah.
it's crazy. to
Yeah,
me.
we have a case, Brady, where you have to disclose things. You have to disclose things to the defense. You have to provide them with the discovery. You have to give them a fair shake at things. And when they're withholding or modifying or changing things, and it happens, it's an uneven playing field again.
Yeah, I mean, the government controls all of this.
Yeah.
So Bill asks, should the drone video have been allowed that late? And we'll take that as a no.
Yeah. So, and the bill, that's a really good question. When I was a prosecutor and we would get 11th hour evidence like that, which, trust me, police departments do that all the time. A case is going to trial for months, maybe years. The week before or a couple days before, all of a sudden the police department's like, oh, I found this new video. Here you go. And it's awful, and it puts you in an awful situation as a prosecutor. And so generally, I mean, I think we were pretty fair prosecutors.
Yeah, I wouldn't object to a continuance. And that's the remedy.
I mean, that's the remedy, is you say, look, we've got this new video. I apologize to the court. I apologize to the defense attorney. Either you can have a continuance or we won't use it.
Right.
Right? I mean, it's one or the other. I mean, you want to make sure that the defendant has, even as the state, you're supposed to make sure the defendant has a fair trial. It is when we were sworn in as prosecutors way back in the day, we took an oath to uphold justice, not to seek conviction.
Right.
And that's the ideal. When you have prosecutors who don't feel that way, like
win at all costs.
Win at all costs, you see these kind of abuses. I think that what the prosecutors should have said is continuance, or we will not use this. That would be the fair thing that would preserve Kyle's rights.
The district attorney's website for this actual case says they will not only seek convictions, but also seek justice.
Oh, that is gross. Really? No, I mean, it is that upsets me at my core.
Okay, so one final topic, and then we'll take some questions. Some of the tactics they used against Kyle are similar, what I believe are similar to cross-examination questions that you might use against a law enforcement officer. So they were asking him de-escalation questions, lower levels of force, things like that. Is that common in all self-defense cases? Is that unique here?
This is a trend, and gun owners, you need to be aware of this because the times they are a-changing. Everything that you have seen, how police officers get pulled across the coals for their use of force, the way that they responded to a threat, all of those trends are coming to the civilian world, and we see it in Kyle's case. And so it's something that, you just kind of have to prepare yourself for. De-escalation. Most of us aren't trained on de-escalation. I have a Texas LTC, and we have to take a little segment on that, but it's probably 15 minutes. But police officers get hours of training on that. Or another good example is, police officers, we have this big spectrum of force of, assertive verbal commands all the way to deadly force. And police officers have all these different tools on their tool belt, between those two places. And they're starting to say, hey, civilian, why didn't you use pepper spray, taser, baton? Why didn't you use, arm locks? That didn't come up in
Yeah.
Kyle's case, but that's what we're seeing happen.
Well, what came up in Kyle's case, though, is this issue of threat assessment, which
Right.
they really, police are trained in threat assessment. Civilians are not. And so when we were talking about that last character who was wounded but not killed, and the prosecutor is saying things like, well, but he had a handgun and you had a rifle. So that, you should have known that that wasn't really a threat, which is absolutely insane. But that's the sort of things that they have always tried to use against police officers. And Richard's absolutely right. It is a growing trend. It has gotten really, I would say the last 2 to 3 years is when it has really exploded. It is completely unfair to civilians. And yet, I don't think there's a DA's office in any state in the country who isn't thinking, this is what we do on self-defense cases now.
Wow, and that's why it's crucial not only to have a good criminal defense attorney, but a criminal defense attorney who is very knowledgeable in self-defense and gun laws. All right, let's take some live questions here, and some of these go back to what we talked about earlier. DJ asked, "What is the best type of round to carry as far as legal proceedings go?"
Well, I mean, under federal law, there's only one type of round that we know is prohibited, and that's armor-piercing handgun ammunition. That's ammunition that's designed and intended for use in handguns, and most ammo is not, armor-piercing handgun ammunition. But I mean, I say use what's legal, what you're trained for, what you're comfortable using. You don't want to be using something you're not used to. I mean, what do you say?
Yeah, I mean, and I'll just, I can only speak to me personally, and that's, I am going to use what is going to keep me safest. I'm going to let Richard deal with the aftermath if he ever has to in a court of law. And people ask these questions like, should I modify my trigger? Should I carry hollow point rounds? I'll I guess add on to your point, which is, I would ask you not to buy the hollow points with the really scary names. Because when it comes up in court, it's nicer if it's just, a critical duty round as opposed to an RIP round, because they're just, how that's going to sound, what the prosecutor's going to do. But like, you catch me carrying on any given day, I've got a modified trigger because, love my carry gun, but the trigger pull is garbage. I've got a modified trigger. I carry hollow point rounds. I know that there are risks in that. I choose to take the risk. So it's very personal.
Yeah, the other thing, I mean, and just coming up with modifications and things like that, I mean, pretty much the only thing I'm advising against is things that if you wouldn't want it published on the front page of the newspaper, you probably don't want it on your firearm or in your firearm. Dust covers that have cheeky sayings on them or engravings on the gun. I would like to steer my clients away from that kind of stuff if they have it.
Oh, certainly.
Okay, here's a good one. Given all the shenanigans and all of the stuff that we've just talked about for 30 minutes, could the defense have asked for a bench trial? That's a question from Jack.
Oh, boy. I mean, Jack, that is an excellent question. And it is something that tactically you have to weigh very carefully, especially when emotions are going to be high. I know the general wisdom is when your client's life is on the line, you put that decision in the hands of 12 people rather than in the hands of one. However, I mean, there are times and there are cases where, you have something that is, they obeyed the law. However, it is so emotionally or politically charged, you don't want to put it in the hands of a jury. You want that detached legal mind to be making the decision. I would say I would not have wanted a bench trial here. Now, knowing what we know now, knowing the judge is pretty friendly, that's all hindsight. But just the defense attorney did the right thing, in my opinion, by not asking for a bench trial. What do you think, Richard?
Yeah, I probably would have stuck with a jury trial. We all have a right to have a trial by jury. But even if they wanted a bench trial, and this is not uniform across all jurisdictions, the state, the government, they have a right to have a jury trial in many jurisdictions. So even if the defense attorney wanted a bench trial, depending on, what the jurisdiction, what's binding on their jurisdiction, the state could have said, we have a right to a jury trial just as much as the defendant, and we want a jury trial. So I don't know that it would have made a difference.
Yeah, both in a lot of jurisdictions, and I actually don't know about Wisconsin. I can speak to here in Texas. Both parties have to agree.
Yeah.
All right, here's a good one. would he ever be able to own or carry or have a CCL, concealed carry license after this case with Kyle?
Yeah, it depends on the outcome. You know, if he's convicted of a murder charge, that's absolutely going to be a felony under state law. That would be a lifetime prohibition on even the possession of firearms and ammunition for life. But if he's acquitted, you know, that let's say he's found not guilty on all charges, you know, an acquittal should not act as any kind of disability to your right to possess or keep or own firearms or ammunition. And I hope it wouldn't impose on your ability to get a license.
No, I would hope not to. Now, of course, you know, we can speak to the licensing laws here in Texas,
Right.
you know, Wisconsin, Illinois, you know, any other place he's trying to get a license.
Any of the may issue states, they might say, hey, you were charged with murder. We're not going to give you a license.
Yeah, the possibilities are endless.
Yeah.
Now, and of course, the jury charge here, which, you know, those are the instructions that the judge reads to the jury before they go back and deliberate. The jury charge here, I think I basically fell asleep. It was hours and hours long. It was crazy long. I don't remember there being lesser included charges in that jury charge. I don't know if you recall, Richard. I think it was just those 5 counts. But so that's another sort of choose your own adventure angle to this is if they had included lesser includeds and he had been convicted of misdemeanor offenses, well, his gun rights later on are different than being convicted of felony offenses, being convicted or, you know, acquitted entirely. So there's a lot that can go on in a trial like this.
Yeah, so in Texas, we're a shall issue state, and if he is acquitted, he can still get a concealed carry permit here. But for example, California, the individual sheriff gets to make a determination as to whether or not this person is dangerous or whatever, and might very well say, I don't care if you were acquitted, I think you're a danger to society, you're not going to get your concealed carry permit.
Yeah,
Yeah,
that's exactly
absolutely.
right.
Okay, so here's a good one. We talked about this, but not this nuance. So Jack asks, should a defendant delete his Facebook account and go completely offline?
And this is one of those things where you have to speak to your attorney before this, before making that kind of decision, because that could be tampering with evidence. And you're depending on what state you're in. But it's a really good question. The only person who's going to be able to tell you that is an attorney representing you on your specific case. It's a great question,
Yeah.
though.
I mean, we're Texas lawyers, and our general advice to people is not delete because you hate to risk that tampering with evidence, but go silent, lock it down.
Go private.
Go private, because even anything you do, and as prosecutors, when we would see cases come in, and we're talking about 2013, 2014, or years ago, one of the first things that the investigators on that case would do is pull your social media and start logging and start documenting. And, today I can imagine, of course, we've been criminal defense attorneys for years now. I can imagine it's even worse today. So, that is something you need to talk to an attorney fast, because within days of your self-defense incident, they are capturing every bit of social media you have. And if you need to lock it down, it's got to happen quick.
And not even just that. If they're subpoenaing Facebook has an entire division of their company that's designed, all they do is respond to government subpoenas. And, your chats, things that aren't even public on your Facebook, your chats with other people, messages that you type but delete, they keep that data. And Facebook is turning it all over to the government. So you got to be very careful. They have said there's no expectation of privacy. You're using this third-party platform. You got to be very careful with social media.
Copying and pasting that, this is all private, Facebook can't share, that means nothing. By the way, for anyone who does that, that means absolutely nothing. But no, and I think, this is just our standard defense attorney advice. If you get in a self-defense incident, everything that you write down from that day until your trial day, do not write it down unless you're comfortable with an exhibit sticker at the bottom and a jury reading it, because you never know.
Yeah, in some states, you even get what's called a spoliation instruction at trial, and the judge will instruct the jury that if they destroyed or deleted that evidence, you can assume that they did it with the intent to hide something from you.
Yeah, and that you can actually assume that it was
damaging.
Yeah.
I deleted my Christmas picture and I have my gun rack in the background. You can get an instruction against you that you did that intentionally and that was damaging.
They can hold it against you. Yeah.
All right. So Mike asked, do you think case law will be made in reference to technology, videos for the future, but just because of this case?
For Wisconsin.
Yeah, for Wisconsin, absolutely right. there are the cases that push the envelope with new types of evidence every single time. Most of the evidence in this case, I would say, is not particularly novel. Whenever we see new case laws, when something's pushing the envelope, and maybe there's a little bit to be said about video enhancement, video enhancement, or resizing, or AI. They had some AI-driven generated video, so we might see the envelope get pushed a little bit right there. But that's as a casual observer, what makes case law is novel issues.
Yeah. Well, and of course, this is any law that's made in this case applies to Wisconsin,
Right.
but would have no effect on any other state, except if there was no case law out there, and then maybe you want the judge to look at it as just persuasive, not controlling. But another issue that they're having in this case, which I think is very interesting, is the jury reviewing this video over and over again. They might make law through that, because there were arguments from the defense basically saying, look, there's case law that says a jury looking at a video over and over and over again is impermissible because it's damaging. But then the prosecution distinguishing those cases saying that only goes for witness statements and the defendant's statement. That can be damaging, but there's nothing in our case law that says you can't look at videos of the scene. And this might be the trial that makes the case that, okay, there's actually, you cannot look at videos of the scene as a jury in Wisconsin over and over and over again because it's damaging to the defendant. I mean, that's certainly possible. I mean, Mike, I think it's a great question, because that's the possibility weighing on my mind.
Yeah.
All right. Let's see here. Jill asks, could the defense call an expert to discuss the difference between what Kyle was thinking and how it appeared in the video?
So, I mean, there are experts for all sorts of things. You certainly want, and this is something I know that because we've spoken to these experts before. There are experts out there who will talk about, yes, what the video captured versus what that person probably saw and perceived. And the way they're generally going to do that is the expert's going to sit there. They're going to watch the video in the courtroom. They're going to listen to the testimony of the person who was actually confronted in the self-defense incident. Then they're going to get up on the stand and they're going to analyze it for you. We actually had that happen in a case once, and unfortunately, I'll tell you, that is very expensive because the expert's got to sit there at trial the entire time. I mean, I had a trial once where the expert had to do that. Look at the judge made a ruling in advance. The expert cannot talk to my client ahead of time. It all had to be very neutral, very detached review. And so he had to sit there in the courtroom for days and days and days. And it cost us like $30,000 just for his courtroom time to be there listening so that he could then give his testimony. So, I mean, the answer is yes. However, your average Joe, I don't think, can afford it, even though it could be critical to your case.
No, and there are experts for, when I say everything, there are experts for everything. One I just heard about, there's an expert, and they're doing all these cross-disciplinary things now. How fast can people turn around? That's the only thing this person testifies on. How fast can a human being turn around? And they're a sports medicine expert. But they're getting brought into these self-defense cases because you see all of these different issues. It's a really interesting question, and it raises something that I was thinking about that really was kind of aggravating throughout the trial, is the speculation. There were so many speculative statements that the prosecutor was eliciting, and I wish the defense would have been just a little bit more aggressive with, what do you think this person thought, or what do you think this person thought? And that's one of those things where you can't get in the mind of somebody else. That's kind of improper testimony. Going back to our dirty trick spectrum, I'd say that's right in the middle. But that was kind of aggravating.
Well, and there are a lot of people out there really mad at the defense attorney because the defense attorney has been very passive. And, I will say, in his defense, you don't know tactically what's going on. Maybe he knows that judge well. Maybe he's got a really good idea of who his juror pool is. He wants to let these things play out rather than kind of be that guy jumping up and down. Maybe he thinks it looks like he's hiding something. But yes, that is very frustrating.
Yeah.
All right, so we've got one more question here, and this is, I think, will cap us off pretty good. Question we got is Rittenhouse on trial, or the Second Amendment and self-defense laws?
I'll let you answer first, Richard, then I'll go.
Yeah, all law-abiding gun owners and the Second Amendment are under a constant assault. And it comes from a lot of different angles. Who can possess firearms, what firearms we can possess, how we can defend ourselves, and that's what we see in the Kyle Rittenhouse case. I think there is I mean, the Second Amendment, think definitely is on trial.
Yeah, the Second Amendment's on trial. Gun owners generally on trial. I think your right to use self-defense, period, is on trial. This case is, I mean, political. Political is all get out. And it is scary because I think, frankly, most self-defense cases these days are taking that tinge. And it's something to be very wary of. I mean, when you have to defend yourself, you have to defend yourself, but know in advance that the chances that you're made, a political sideshow, because ultimately we're trying the Second Amendment, not the actual defensive incident. I mean, the chances are just so high.
And James followed that up, or maybe asked it at the same time. If he's found guilty, what kind of impact could we see in the future of self-defense cases?
Well, I think it's a real chilling effect on people wanting to defend themselves, defend their families, defend their loved ones. Because if, in my opinion, upon my review of this case, it seems very clear cut that this is a justified use of force case. And so when you see a justified use of force case, being found guilty for the wrong reasons, it creates a lot of ripple effects in society that I don't think we want to see.
Yeah, I couldn't have stated that any better. I think that we see a guilty verdict in this case, that anyone who needs to defend themselves after this case is you risk losing your own life because you're second guessing whether or not you can without going to prison for the rest of your life. And it's I think a scary thought.
It's scary.
Well, we're going to wrap it up here. Thank you to everyone for participating, all the great questions. Thank you for watching. As you've heard today, even if you've done everything right or close to right, there's a lot behind the scene as far as prosecution, the evidence, social media, things outside there, and that's why it's crucial to have a criminal defense attorney, not only a criminal defense attorney, but one extremely experienced in self-defense law and gun law. For more information about U.S. LawShield, go to uslawshield.com. And thank you again. We appreciate your time today.
Thanks, Kirk.
Thanks, guys.